This is part 2 of a 4-part video series dedicated to walking you through the domestic violence process. The first step in getting protection is to go to a magistrate court in any county and fill out a form for an emergency protective order. The form is called a domestic violence petition, and the person who files it is called the petitioner, because that person is petitioning or asking a court for something. The person who is accused of domestic violence is called a respondent, because he or she will have an opportunity to respond. The form used to file a domestic violence petition is available in all magistrate court offices in West Virginia. Forms can be filled out and filed in the same visit to magistrate court. Magistrates in every county are on call 24 hours a day, 7 days a week, to review this type of petition immediately when one is filed. Petitions can also be filed in any county, no matter where the people involved in the case live. Magistrates can transfer a case to the home county if necessary. Police officers can transport victims to magistrate court so that they can fill out a form for an emergency protective order. But anyone can go to court on his or her own without law enforcement to file a petition. On the form, the most recent acts of domestic violence must be included, but the person filing the petition can include information about past events. The form must include the name and address of the person filing the petition and the name and address of the person accused of domestic violence, as well as the names and addresses of any children involved. For safety, anyone seeking a protective order can request that their own address be kept confidential. The person filing the petition needs to provide as much information as possible about the individual they are accusing, so that the individual can be found by law enforcement. Officers must personally give the accused person a copy of the petition. If the accused person's address is a post office box, the person filling out the petition must provide written directions to the place that person lives. It is very important to put in the petition whether the accused person has access to any firearms or ammunition. Once a petition is filed, the magistrate who received it will hold an emergency hearing. The magistrate will ask questions to the petitioner. If the magistrate decides that there is evidence of an immediate and present danger, the magistrate will issue an emergency protective order. Now that we've discussed the petition and emergency hearing, it's time to cover the emergency protective order and the respondent's rights. Continue your viewing with Part 3 as we walk you through the rest of the process.